So, welcome back to another episode of Intellectual Property. In this lecture, we're going to be discussing both the idea-expression dichotomy and the arguably related useful articles or kind of copyright functionality doctrine. So as you recall, in our previous class, we discussed the subject matter of copyright protection. Both of these doctrines really go to the subject matter of copyright protection as well. So in our last class, we recognized that the constitutional requirement for copyright protection is originality, which consists of both independent creation, or the element of the work in question not being copied from somewhere else, as well as the creativity requirement, which is a little obscure, but seems to require that there be some degree of uniqueness or expression embodied in the element of the work in question. Now, the idea-expression dichotomy and the useful articles doctrine really go to a similar question, however. They go to, when is it that a work or an element of a work can be subject to copyright protection in the first place, not on the basis of originality, but on the basis of whether it satisfies the kind of fundamental requirements or expectations that we have for copyright protection to attach. And so, one way to think about this is in the context of the idea-expression dichotomy, which essentially says that only the particular concrete elements of a work of authorship can be the subject matter of copyright protection, and the abstract elements can't. In other words, copyright can't protect ideas, it can only protect particular expressions of ideas. So the most abstract elements, the most idea-like elements of a work can't be the subject of copyright protection, but the literal elements that actually constitute the work itself can. The problem comes in when you find yourself somewhere in between the two, right? So the broad idea of a work of authorship can't be protectable. So if you think of like a romantic comedy, right? The storyline or the kind of the plot element, boy meets girl, boy loses girl, boy regains girl, that can't be the subject of copyright protection. It's too abstract. It's just a kind of kernel of an idea for a story, almost a kind of schematic description of the typical form of a romantic comedy. But as you add additional particularities to the story, eventually it gets sufficiently particularized that perhaps it could be the subject of copyright protection. So there's this kind of gray area in between the two, where whether something counts as an idea or expression can be unclear, and there's sort of a fact-specific question as to whether those elements can be the subject matter of copyright protection when they fall somewhere in the middle of the spectrum, as it were. And of course, we'll discuss the idea-expression dichotomy further later in the class in relation to other cases. But one nice illustration of the idea-expression dichotomy is in the 19th century case Baker v. Selden. Now, what happened in the case was that a man named Selden had produced a book, it's really more of a pamphlet in a lot of ways, briefly describing a method of double entry bookkeeping and then providing a series of forms that one could use to execute the form of double entry bookkeeping. So this is a way of keeping track of the finances of a business. Selden thought he was going to make a bunch of money selling copies of this book to various people. It turned out it wasn't very popular, probably at least in part because he didn't do a very good job of explaining it, right? There wasn't a whole lot of actual words in the book in question. It consisted almost entirely of these forms which you were supposed to use to accomplish the method of bookkeeping. Now, Baker, many years later, came out with his own book describing a very similar, broadly speaking, identical method of double entry bookkeeping, and also providing a series of forms which were similar or almost identical to the forms provided by Selden. In the interim, Selden had passed away. And Baker's book started selling, and it was very successful. It explained the method in a much more effective way, and it turned out to be quite popular. Well, Selden's widow filed a copyright infringement action against Baker, alleging that Baker had copied the method of double entry bookkeeping and had copied the forms in question. Lower court found in favor of Selden, but the Supreme Court ultimately reversed, holding that the method of double entry bookkeeping itself could not be the subject of copyright protection, right? If anything, it was an invention or discovery that could be protected by a utility patent, but it couldn't be protected as a copyright because it was an idea, not a particular expression of an idea. So Selden could claim, or Selden's widow could claim, copyright ownership over the particular words that Selden used to describe the method of double entry bookkeeping in the pamphlet, but couldn't claim copyright ownership over the method of double entry bookkeeping itself. If that was protectable at all, it was protected only by a utility patent. And because Baker had written his own book describing in different words the same idea, it couldn't be infringing, right? Because the idea couldn't be the subject of copyright protection, only the specific expression. And Baker was only copying the idea. He wasn't copying the particular expressions, and so his book couldn't be infringing. Now, there was an additional claim which related to the forms that Selden included in the book. And so the argument was, well, even if the book itself isn't infringing, perhaps copying the forms could be infringing because the forms are in fact the same, more or less, even though the words used to describe the method are not. And the court said, no, the forms also could not be the subject matter of copyright protection, even though they were in effect copies, because the forms were a means to an end of achieving the method of double entry bookkeeping. In other words, the forms are kind of a concretization of the idea. They just represented the method. They didn't actually add expressive content that could be the subject matter of copyright protection. In other words, the forms were kind of like a tool, like a accounting tool for accomplishing the goal. And the tool itself, again, couldn't be the subject of copyright protection. It was the concretization of the idea, not a particularized expression thereof, right? So core takeaway here being that in order to allege copyright protection, you have to allege not only the copying of the kind of the broad idea of the work in question, you have to allege copying of this particular way in which that idea was expressed. Now, we also have something called the useful articles doctrine, which in a lot of respects kind of occupies a very similar role with respect to the functionality of products and product design. So what happened here was a company run by the Steins produced these lamps, which were popular in the 1950s. Porcelain lamp bases, you could pick the lamp base of your choice and then have it sold to you with an actual lamp installed in the lamp base. So Stein generated a whole bunch of these different porcelain lamp bases, which they registered with the Copyright Office individually as lamp bases, not as lamps, rather as sculptural objects, not as lamps. And Maser started making copies of these lamp bases and producing their own lamps. Stein brings a copyright infringement action against them, and the defense is, look, these are useful objects, right? These are things that you use in your home. These are just essentially industrial design. If these are going to be protectable by anything, they're going to be protectable as design patents, not as copyrighted works of authorship. And because a lamp is a useful object, you can't claim copyright protection in a lamp. It's just not the kind of thing that copyright is intended to protect. Well, the Supreme Court rejects the contention and says, look, we can separate the lamp base from the useful object, and the only thing that copyright is protecting is the ornamental qualities, the kind of the expressive aspects of the lamp base. And we know that under Bleistein, copyright is indifferent as to the intended purpose and the nature of the work in question. Copyright just says, look, if it satisfies the requirements for copyright protection, then copyright attaches, and it doesn't matter if it was intended to be a lamp base or not, right? it looks like a sculpture, if it looks like a sculpture, if it feels like a sculpture, if it works like a sculpture, it's a sculpture for the purpose of copyright protection. And it doesn't matter that the intended purpose of the sculpture in question was to be turned into a lamp base. After all, Stein could theoretically have sold the exact same sculptures with no lamp base attachment at all, and then they would clearly be the subject matter of copyright protection. Even if you don't think they're very good or very aesthetically appealing, it just doesn't matter under the Stein aesthetic non-discrimination doctrine. They satisfy the objective criteria for copyright protection, therefore they're protectable, irrespective of their relation to the lamp, specifically because they can be conceptually and physically separated from the lamp in question. So there's this idea of conceptual and physical severability, right? In other words, can you take a particular element of a work and remove it from the useful object? In other words, a lamp is a useful object, right? But you can have a lamp without a decorative base. And so by removing the decorative base and looking at it in isolation, it becomes conceptually and arguably physically severable from the lamp itself, and therefore can be considered independently as the subject matter of copyright protection. Here you can see an example of an advertisement for the California modern lamps being sold, and see a kind of a graphical representation of the lamp in question. Okay, and then finally we'll talk about the most recent iteration of this severability context, which was decided by the Supreme Court in Star Athletica v. Varsity Brands. What happened here? Well, Varsity Brands was a manufacturer of cheerleading uniforms. Star Athletica was kind of a spin-off of a company that they'd previously been working off. They're competitors in the same market. And Varsity Brands goes and registers the design of the cheerleading outfits that they're producing, and then alleges that Star Athletica is copying their cheerleader design. So above on the top row here, you can see pictures of the registered designs. Below, you can see images of the Star Athletica cheerleading outfits that allegedly copy those designs in question. Well, the response from Star Athletica is, look, copyright doesn't protect useful articles, and the paradigmatic form of useful article is clothing. Well, a cheerleader uniform is just clothing. Copyright doesn't protect clothing. Therefore, they can't claim copyright protection over the design of a cheerleader outfit. It's just a useful object. It's not the subject of copyright protection. Therefore, their claims have to fail because no copyrightable subject matter. Okay, well, back and forth in the lower courts, ultimately the Supreme Court finds in Varsity Brands' favor and says, no, they're not precluded from claiming copyright protection over the cheerleader uniform designs, right? Because you can represent those designs in another context. Indeed, look, you can see them right here. Here's a drawing of a design. Here's a photograph of a design, right? Is the design a cheerleading outfit? Is the design clothing? No, the design is an image, right? The image happens to appear on clothing, but it doesn't matter, right? I mean, there's no question that if you print a picture on a t-shirt, the picture is protectable. Well, these are just abstract pictures printed on clothing, no problem. They're protectable by copyright. Now, interesting to note, right? Does the Supreme Court in this case say that the designs are actually copyrightable? No, it says that they're just at the very least not precluded from being protected by copyright simply because they're pictorial designs on a cheerleading uniform. It doesn't actually evaluate whether they meet the standard for originality and therefore are actually copyrightable subject matter or not. It's simply saying that the fact that they happen to be on a useful article, on a piece of clothing, doesn't preclude them from being copyrightable subject matter. Now, you get a really interesting dissent from Justice Breyer arguing that the standard adopted by the Supreme Court just doesn't make sense because any useful article can be pictured in a drawing, right? So the necessary implication of the majority's position is there's no such thing as useful articles or severability anymore because literally anything can be pictured. And if you can picture it, according to the majority, then it's not a useful article anymore. It's the image of a useful article. And that just doesn't seem to work, right? The dissent points out that, like, look, the fact that you can draw an image of a shoe doesn't mean that a shoe is copyrightable subject matter. The fact that you can, picture a shovel doesn't make the shovel a copyrightable subject matter, because it's a useful object, right? And the picture is not sufficient to make it no longer useful. In other words, a mere graphical representation can't constitute or shouldn't constitute severability for this purpose, because treating it in that way would just eliminate the useful article doctrine entirely.